2. For AU visa applicant. Form I-192, officially titled Application for Advance Permission to Enter as a Non-Immigrant, is required for individuals seeking a waiver of inadmissibility when applying for AU visa or certain other non-immigrant statuses. Approval of this waiver allows the applicant to continue their immigration process without being barred from entering the United States. This guide focuses specifically on how to complete Form I-192 for AU visa applicants. For detailed step-by-step instructions on filing Form IR-918, the main AU visa application, refer to filing an IR-918 petition for AU visa. The following instructions apply to the version of Form IR-192 issued on April 1, 2024. Additionally, we'll cover recommended supporting documentation that can strengthen an IR-192 waiver request. If you're looking for details on whether you qualify for this waiver, see How to Qualify for Waiver of Inadmissibility as AU Visa Applicant. Step-by-step guide to completing Form I-192. The latest version of Form I-192 is available for free download on the USCIS website. Part 1. Application Type. Question 1. Select the first checkbox to indicate that your application relates to AU visa. Part 2. Personal information. Questions 1 to 2. Enter your full legal name and any other names you've used, including nicknames or maiden names. Question 3. If applicable, provide your alien registration number, A number. This number is typically assigned to individuals who have had prior U.S. immigration history, such as lawful permanent residents, individuals in deportation proceedings, or those who previously applied for a work permit. If you do not have an A number, leave this field blank. Question 4. If you have a USCIS online account number, enter it here. If not, leave it blank. Questions 5 to 8. Provide your date of birth, gender identity. Options include male, female, or another gender identity, place of birth, and current country of citizenship. Questions 9 to 11. List your current residential address, at safe address if applicable, and all previous addresses where you've lived over the past 5 years. If you've only lived at one location, write same as above. Marital status and relationship information. Current marital status. Indicate your current relationship status by selecting one option, e.g., single, married, divorced, widowed. Information about your spouse. If you are currently married, provide the full name, date of birth, and A number, if applicable, of your spouse. Details on previous marriages. If this is your first marriage or you are single, you can skip this section. If you were previously married, enter information about past spouses, including their full name, date of birth, and any relevant immigration details. Immigration and criminal history. Question 26. Grounds for inadmissibility. Here, you must specify the reasons why you are considered inadmissible under U.S. immigration law. Carefully review the relevant statutes or consult with an immigration attorney to ensure accuracy. Provide both the statutory reference and a brief explanation. For instance, if you entered the U.S. without inspection, you might write INA 212A6A for unlawful entry into the United States. If multiple grounds of inadmissibility apply to your case, list each one clearly. Keep in mind that the public charge rule does not apply to U visa applicants. Questions 27 to 29. Prior applications for advance permission. If you have previously applied for advance permission to enter the U.S. as a non-immigrant, indicate whether you have submitted a U visa application before. Provide details such as the date and location of your prior application and check the appropriate box. Question 30. Presence in the U.S. for 6 months or more. This question determines if you have been in the U.S. for 6 months or longer. If your stay was unlawful, you could be at risk of inadmissibility due to unlawful presence. However, if you remain in the U.S. while your U visa status is pending, this should not impact your eligibility. Questions 31 to 34. Previous immigration applications. These questions assess your immigration history, including any previous petitions or applications. USCIS will use this information to cross-check existing records for relevant details about your case. Questions 35 to 36. Criminal history. Provide full disclosure of any criminal history. USCIS will review this section to determine if your past offences impact your admissibility. Be truthful and include all necessary details. Travel information. Questions 37 to 43, travel and entry details. Most U visa applicants apply for an I-192 waiver while already in the US. If this applies to you, simply write "not applicable" in these fields. However, if you are outside the US and applying from abroad, provide the following details. Questions 37 to 39, port of entry, list the city and state where you plan to enter the US. For example, San Francisco, California, San Francisco Airport if you intend to fly into San Francisco International Airport. If your travel plans change later, it will not affect your application. Question 40, mode of transportation, indicate how you plan to enter the US, such as airplane if traveling by air. Question 41, planned entry date, write the estimated date of arrival in millimeter, DD, YYYY format or simply state as soon as approval is granted. Question 42, duration of stay, instead of listing a specific time frame, write duration of non-immigrant status, since USCIS determines the visa's expiration. Question 43, purpose of travel, provide a reason, such as I am applying for non-immigrant status, or I am assisting law enforcement in the prosecution of criminals who victimized me. Employment history. This section requires details about your jobs over the past 5 years. List your employers, job titles, and dates of employment. Ensure accuracy, as USCIS may verify this information. Final sections. Part 3, Applicant Statement, Contact Information, Certification, and Signature. This section confirms that you understand and take responsibility for the information provided. Carefully review your answers before signing. Parts 4 and 5, Interpreter and Preparer Information. If an interpreter or attorney helped you complete the form, they must fill out and sign these sections. If no one assisted you, simply leave them blank. Part 6, Additional Information. If you need extra space for any answers, use this section. Clearly indicate which questions the additional information corresponds to. By carefully completing Form I-192, U visa applicants can seek a waiver of inadmissibility and move forward with their immigration process. If unsure about any section, consulting an experienced immigration attorney is highly recommended. Essential documents for U visa applicants filing an I-192 waiver. Form I-192 is relatively straightforward to complete, especially for applicants within the United States. However, depending on the specific grounds of inadmissibility in your case, you may need to provide substantial supporting documentation. Due to the complexity of waiver applications, seeking legal assistance from an immigration attorney is strongly recommended to improve your chances of success. Below is a general list of documents that may be required for your I-192 waiver application. This list is not exhaustive, as different cases may require varying types of evidence. In most situations, the I-192 waiver is submitted alongside the U visa application, with many documents serving as evidence for both. Some key documents to consider including are a signed personal affidavit or declaration. This statement should detail the crime committed against you, your cooperation with law enforcement, the significant harm you suffered, and the reason for your inadmissibility. Additionally, outline any positive factors that support your request for a waiver, such as family ties in the US, community involvement, rehabilitation efforts, and volunteer work. Criminal records related to your case, if applicable, submit police reports, court records, or any other official documentation proving that you were a victim of a qualifying crime. Medical records provide evidence of the physical or emotional harm you endured due to the crime. This may include medical or psychiatric evaluations, letters from doctors or therapists, or proof of ongoing treatment received in the United States that may not be available in your home country. Proof of cooperation with law enforcement. While the U visa application requires certification of helpfulness, you may include any additional letters or acknowledgements from police departments or prosecutors affirming your assistance. Criminal history records, if applicable. If you have a past criminal record that necessitates a waiver, include relevant documents demonstrating your history and any rehabilitation efforts. Letters of support, personal recommendations from family members, friends, employers, religious leaders, or community members can serve as character references, highlighting your positive contributions and good moral character. The more specific examples they provide, the stronger your case. Birth certificates of U.S. citizen children or relatives, if you have close family members who are U.S. citizens or lawful permanent residents, providing their birth certificates or other proof of status can demonstrate your significant ties to the United States. Evidence of community involvement or volunteer work, letters from organizations, religious institutions, or community leaders can showcase your engagement and contributions to society. Hardship evidence, if returning to your home country would cause significant hardship, include documentation such as reports from credible sources, news articles, or statements explaining the risks or challenges you would face. Is there a filing fee for U visa applicants submitting Form I-192? Although the standard filing fee for Form I-192 is typically over $1,000, U visa applicants are exempt from this fee and do not need to pay it. What happens after submitting Form I-192? Since the I-192 waiver is part of the overall U visa application, it will be processed together with your case. As outlined in How Long Will It Take to Get a U Visa, the U visa process can take several years for a decision. If you are currently residing in the United States, you may be eligible for deferred action, which helps protect you from deportation while your case is pending. Once you obtain deferred action, you can also apply for an Employment Authorization Document, EAD, commonly known as a work permit. If you maintain eligibility for U non-immigrant status over time, you may eventually qualify for U.S. lawful permanent residence, a green card. Waivers granted earlier in the process generally remain valid, though in certain cases, particularly those involving criminal conduct, USCIS may choose to re-examine your waiver. Seeking legal assistance for your U visa and I-192 waiver application. Applying for a waiver adds complexity to the U visa process, requiring additional documentation and legal arguments. To avoid potential delays or denials, consider working with an experienced immigration attorney. A qualified attorney can help assess your case, identify any potential challenges, ensure your application is properly prepared, and track your case's progress to increase your chances of approval.